All right, we will call the Senate Judiciary to order. Would the would the Secretary please call the roll?
Senator Harris? Here. Senator Orenshaw? Here. Senator Dondero-Loop? Here. Senator Wynn? Here. Senator Hansen? Here. Senator Krasner? Here. Senator Stone? Here. Chair Scheibel?
Here. Welcome back after a couple days off for inclement weather. I apologize. We had to cancel our committee the last 2 days along with everybody else. Just so you know, I am working with the sponsors of the bills that were supposed to be presented, one of which was myself, to get those hearings rescheduled, and we will have new schedules out for you shortly. In the meantime, we're going to continue with our agendas as they have been posted for today and tomorrow. And today's agenda includes one bill, SB 63, and I'd like to invite I'll open up the hearing now and invite the presenters up to the table to give us a rundown of the bill whenever you're ready.
Thank you, Chair, members of the committee. For the record, my name is John McCormick, John, last name McCormick, McCormick. I'm the Assistant Court Administrator at the Supreme Court, and today I'm here to present Senate Bill 63, which, at the risk of jinxing myself, I would refer to as a cleanup bill. Or at least the vast majority of it is a cleanup bill. Absent any sort of objections, I will just take a quick run through the bill and the sections. Section 1 requires the contact information for courts to be made available to the public. It's modernizing language to include contact information rather than just the telephone number. So again, cleanup and modernization there. Section 2 modernizes the language around holding court during emergencies. I personally was a big fan of the existing language of when war, pestilence, or other public calamity or dangers thereof create an emergency, but rather this proposes to modernize that and just say emergency conditions. Section 3 includes location for clarity's sake and where court can be held. Section 4 clarifies language on who can be excluded from a court proceeding. And previously, the statute read that you couldn't exclude a minor if they were the person on trial or the minor was a law student preparing to apply for a license to practice law. I think this might have been an 1865er. So the proposal there is to take out the reference to a minor who's studying to be a lawyer, because that's not how that happens anymore. Section 5 modernizes language around e-filing rules, which is fairly important since at AOC we are currently in process of working on a statewide e-file system. Section 6 removes or replaces telephone with electronic communication, just to acknowledge that we do work beyond just the telephone now, and that pertains to being open for the issuance of a protection order, Section 7 cleans up the requirements for the courts to have seals to affix to documents, and just actually requires that each court of justice in the state shall have a seal, and the Supreme Court can adopt rules regarding those seals. Section 8 removes the current statutory procedure for disqualification of a judge and would put that in the purview of Supreme Court rules. I would anticipate there may be concerns about this section. We're open to working with people going forward on that. Section 9 modernizes language regarding the court administrator's office, so the AOC, to remove old-timey, for lack of a better term, provisions where the AOC would go examine the docket books of the court and determine if they needed assistance that way. So just remove some of those old, some of the old provisions, rather. Section 10, there's a number of sections here that remove regulations and replace it with rules, because the Supreme Court or courts promulgate rules, they don't promulgate regulations. So that one is a word change there in Section 10, and we'll see that repeated a few times throughout. Section 11, Section 11 modernizes language regarding the payment of interpreters to say that fees as a court determines are reasonable and necessary for an interpreter, rather than the courts by whom they are employed shall certify to be just as far as the compensation. So it's a modernization there. And just by way of news note, in the State Court Administrator Guidelines for the Court Interpreter Program, which are the governing document there, within the last year, we increased the recommended hourly rate for interpreters from $25 to $49 after surveying a number of states, and that puts us right in the neighborhood with the vast majority. Section 12, again, clarifies rules versus regulations, and changes the language regarding the interpreter program to indicate that it operates pursuant to legislative appropriation. So nothing particularly new there. Section 13 is another regulations to rules section. Section 14 takes out, because this is the composition of the Certified Interpreter Advisory Committee, takes out the references to counties under 100,000 versus over 100,000, just for ease of, or not ease, but for the membership of the committee. Also provides that the court administrator may designate among the members of the committee a vice chair to serve. That provision didn't exist before. Also, we do update the language to the preferred nomenclature of persons with limited English proficiency in these sections. Section 15, again, changes regulation to rule, just in terms of the reference. Section 16 replaces the current statutory procedure for requesting review of a background check results with the court administrator guidelines. So it just updates that procedure to conform it with our rulemaking authority in terms of this program. Section 17 clarifies or modernizes or clarifies some of the language regarding the appointment of a justice when there's a vacancy on the Supreme Court, and clarifies the term. That's related to some existing case law about those terms, but it just clarifies when the appointed term runs to, which is the Monday after the next general election. So obviously the individual has to run in that general election. Section 18, currently there's a requirement that if a Supreme Court promulgates rules, they can't go into effect less than 30 days after the entry of the order. In the event that there's emergency rules, this can be problematic, and generally the court tends to give longer than 30 days for people to become familiar with rules, so that just removes that requirement in Section 18, so the rules can become effective when is necessary and proper. Section 19, and I will mention this is a companion with Section 27, which is these are the two sections of the bill that we're currently working on with various stakeholders. They pertain to the provision of facilities, staff, a budget, et cetera, for either the Supreme Court or the district courts in Section 27. And so we have been working with Clark County, Washoe County, various interested parties to get these all cleaned up and to everyone's liking, and we want to marry up the language in 19 and 27 so it is the same across the board. Section 20 talks about the use of digital signatures, and says the Supreme Court will promulgate rules on digital signatures if necessary. Section 21 deals with the appointment of the Supreme Court clerk. It takes out the old language from when this statute, I think, initially happened maybe in the 50s, and just indicates the clerk of the Supreme Court will be selected by the Supreme Court. I think that's pretty standard. Section 22, 23, and 24 all remove "or a majority thereof." It currently reads the Supreme Court or a majority thereof is authorized to designate any person, blah, blah, blah. And the majority thereof seems to be unnecessary there because that's how the court operates on majority vote. So I don't think that that's necessary there. I don't know if we were trying to contemplate unanimous versus majority, but again, that's a language cleanup. Section 24 cleans up language a little, or modernizes language just about why the Supreme Court can have necessary employees for the operation, maintenance, and improvement of the court and the state court system. So it's a little more broad than, secretarial support, which was the original language in the statute. Section 25 just again updates and removes regulations regarding the law, the language regarding regulations regarding the law library, since the court does not promulgate regulations, it promulgates rules. Again, Section 26 does that same thing, just recognizing that. Section 27, this is the one I mentioned that we've been working with Clark County, Washoe County, the 8th and the 2nd Judicial District, and we'll work with any other interested parties, NACO or whomever, regarding the language on what must be provided for the district courts. Section 28 is another removal of regs. So is Section 29, so is Section 30. Section 31 is another modernization piece. It modifies, removes telephone and acknowledges electronic means, obviously internet, etc. So again, that's a language modernization. Section 32 is regs, removes regs again, as does Section 33, as does Section 34. Section 35 is kind of an interesting one. It was a random discovery in Chapter 281. It's still referred to having 5 justices on the Supreme Court. So we're just changing it to justices of the Supreme Court because this body has the discretion to increase as they see fit. And we're at 7 now, have been for a while. So, all right. And then, so it does update that. And it also updates to reflect the Harvey decision that the clerk of the district court may be the county clerk. Then we've got Section 36. This one says that the sunset provisions in the legislative report statute don't apply to the statutes that give rise to the annual report. I think that's my guess. LCB would have to correct me if I'm wrong on that one, because I've been wrong before and will be again. Section 37 repeals a number of sections of statute. 1.060, which was again, maybe an 1860s hangover. It's an antiquated provision about the sheriff adjourning court if the judge doesn't show up, and then the judge needing to send a telegram or letter. So figure that one could probably go, being that it's not something we're probably going to encounter. 1.115, this is the statute that requires the courts to recycle to the extent it's reasonable and practical. We do that. Don't know that it needs to be a statutory requirement. 1.116 says that any electronic e-waste that we're getting rid of needs to be cleaned off, which we do before we donate it to Computer Corps generally, or I can't remember who we donate to in Southern Nevada, but that's what we do with our surplus equipment. 1.150 requires the court to have a seal and prescribes what the seal can be used for in terms of judicial business. That one's kind of like, yeah, it's inherent and we kind of need that, so I don't know that it needs to be statutorily prescribed is the idea on that one. 1.170 is who has the custody of the court seal, so that should be the clerk of the court. I think that goes without statutorily requiring that. 1.180 indicates some of the documents that have to have the court seal applied, again, not necessary in statute. 1.270 says that a sitting judge can't have a partner who is practicing in the courts in the state, so sitting judges can't be part of a law firm with partners that practice in the state, except for those small part-time ones. So again, it removes that one. I don't know that we've encountered that. 2.210 not modifies, but says the clerk of the Supreme Court qualifications are set by the Supreme Court. 2.230 was from 1973, and it let the Supreme Court appoint deputy clerks. Obviously, that's within the inherent authority of the court, pursuant to existing case law, et cetera. Again, that's with the removal of 2.240. It's another employee authorization statute. 2.255, our clerk of the court, Elizabeth Brown, really appreciates this. If there's a mistake with fees, she can no longer be fined $1,000, which is what this statute provided, that if the Supreme Court clerk collected unauthorized fees, it was a $1,000 fine. So we'll hope to remove that. Let's see, 2.270 provides that the Supreme Court can destroy exhibits. We don't have new evidence at the Supreme Court generally, being that it's an appellate court, so we don't have a lot of exhibits that we're holding on to, but if we were, we would manage them pursuant to our records retention schedule. So again, this is probably not, this is one that I think is a little bit of an anachronism, still being there. Then we've got NRS 2.420 that says the Supreme Court designates when the law library will be open. Don't think that's necessary to have in statute, being that that's SOP currently. And then 2.440 sets the qualifications for the librarian for the Supreme Court. Again, it's a Supreme Court employee. They set those qualifications. And 2.450, this is one of those that in reviewing, I'm like, I really want to look at the history on this one, why it exists. But it requires the librarian at the Supreme Court Law Library to report to the justices what's going on with the library once a year, which I was like, I wonder what was going on when this was passed that created the need for that. But again, we no longer think that one's necessary. So that is all 20, how many ever pages of this bill? 23 pages on 8 pages of notes, and I'm happy to answer questions.
All right, thank you so much. Questions from members of the committee? Okay, Senator Wynn.
Hi, thank you. And I'm going to kind of bumble my way through this question because something doesn't feel right about it. So maybe you can help and give me some comfort. I'm looking at Section 8, that entire section that is kind of removed from here. And it kind of seems like you're removing like the ethics section. So I'm like, who does that fall on? Are we just going complete self-regulation that the judges are going to regulate and determine what's ethical, what's not ethical? And I may have some follow-up.
Thank you, John McCormick, for the record. The idea there with removing that language from statute is because it's a procedural issue. It should be set by court rule, and the Supreme Court would then promulgate rules regarding disqualification.
Are there problems with the current system that they don't have rules or they're not following this? Like, why does this need to be removed?
Again, for the record, John McCormick. The idea behind, well, there's a couple things. Let me take a step back. One of the problems we have is with this current scheme is we have people who file, for lack of a better term, frivolous or repeated disqualifications, to try to disqualify the whole bench. So we would like to address that. And then also, being that it's sort of a court procedural rule or a court procedure, we thought it would be more appropriate for the Supreme Court to promulgate rules.
So it would be them determining what's ethical, what's unethical, and determining, kind of making those, I guess, what disqualifies a judge from being a judge, and they would make those in their sole discretion.
John McCormick for the record. Well, we already have the judicial code of conduct with those canons, so obviously that would inform it. And then this would be to create the rule for that disqualification. Generally, the process that would be used to develop that rule would be potentially having committee or commission work on it, getting a draft rule, then that draft rule being filed with the Supreme Court under its administrative docket, public hearing, opportunity for public comment, and review of the rule before the court took any action on it.
Just a follow-up, Chair, if that's fine. I don't know. I just feel very uncomfortable removing that procedure that's in statute right now that allows that without having something set up that would give our constituents and the state of Nevada like comfort in knowing that there's protections against that unethical behavior. But I'll continue to reach out with some further follow-up.
All right, other questions? Senator Orenshaw.
Thank you very much, Chair, and thank you, Mr. McCormick, for presenting the bill. If I could ask, if the Court Chair would indulge me in two questions. A follow-up to Senator Wynn's question. The deletion in Section 8 of the language in NRS 1.235 regarding the procedure for disqualifying judges other than Supreme Court justices or judges of the Court of Appeals would leave it to court rule and take it out of the NRS. But I noticed that NRS 1.225, that deals with grounds and procedure for disqualifying a justice of the Supreme Court or a judge of the Court of Appeals. That would remain in statute, so that wouldn't be touched by this bill. That would still, the grounds for disqualifying a Supreme Court justice or a judge of the Court of Appeals, that would remain at the NRS. But if this bill passes with Section 8, then every other judge in the state, the Justice of the Peace, district judges, municipal judges, that would fall to court rule.
John McCormick for the record, yes.
And I guess that concerns me just a little bit, because then I'm not sure why we wouldn't either have it all up to court rule or maybe all in statute, but maybe I can talk with you offline on that. Then my second question, Chair, has to do with the deleted language, and that is at NRS 2.420, hours of use of the Supreme Court Law Library by the public. I know that in this day and age, so many of our constituents have access to the internet and can look up cases in NRS online, but we still have some constituents who don't have reliable internet, and sometimes we'll go down to law libraries, whether it's the Clark County Library down in Las Vegas or sometimes the Supreme Court Law Library. If this passes, can we be assured that there still will be hours open to the public of that Supreme Court Law Library here, just so that the public, if they need to come and look up the books and come down here in person, can do that?
Thank you, John McCormick, for the record. Yes, the Supreme Court Law Library is open, will be open when the rest of the court is open for business, 8 to 5, Monday through Friday. And again, we work with people. We've had people come in at different hours. So yeah, it would be open our regular business hours.
Thank you, Mr. McCormick. Thank you, Chair.
Other questions? Senator Hansen.
Thanks, Madam Chair. I have the same concern about Section 8. That whole thing, I'm very uncomfortable allowing the Supreme Court to have, all 7 members versus 63 legislators who are trying to make sure there is some oversight from a different branch of government. So anyway, I got some heartburn on that, but they've kind of already covered some of the basics of it. Section 14, where you eliminate the requirement to have at least one of those people in a county under 100,000. Why would you remove, now you take out essentially all rural counties. Well, I guess they still could be included, but the way it's set up now, you're guaranteed at least 1 or 2 from one of the smaller jurisdictions. Why the need to remove that 100,000 cap?
Thank you, John McCormick, for the record. As far as getting judicial participation on this committee, it's been a bit of a challenge. So the idea is to open that up. Currently, the Justice of the Peace on there is Judge Primo from Carlin, and before that it was Judge Kevin Higgins from Sparks. So the idea was to just remove that caveat to provide greater flexibility in filling those seats.
So you've actually had difficulties getting people to, because you've got a very limited number of Justice of the Peace, really, when you think about it. Okay, well, that makes sense. Thanks, Madam Chair.
Senator Stone.
Thank you, Madam Chair. Thank you for your presentation. I also have concerns about Section 8. It seems like it's the fox guarding the henhouse. So if this goes through the way you are proposing, who would be governing the ethics of Supreme Court justices and if there's some malfeasance?
John McCormick for the record. Since this is disqualification procedure, the ethical obligations of the Supreme Court justices, district judges, justice of the peace, municipal court judges, masters, et cetera, are found in the Judicial Code of Conduct, which is in Supreme Court rule, and then the oversight body, for lack of a better term on that, is the Judicial Discipline Commission.
Okay.
So this wouldn't impact any of that. This is just regarding
Disqualifications?
motions to disqualify, yes.
Okay. Appreciate that. And then in Section 35, you talked about the number of justices. You said that there are 7 justices now, and if I heard you right, that they can increase that number. I was curious, can the justices do that themselves, and what is the formula for which that they could make that decision?
John McCormick for the record. Sorry, I misspoke. The decision on the numbers of members on the court is within the purview of this body, the legislature, that pursuant to Article 6 creates those seats. There has to be 3, and we've made it to 7.
Okay.
So.
Thank you for making that clear. Thank you very much.
Other questions from Senator Dondero Loop?
Thank you very much. I have a couple of questions on some different sections. One of them is in Section 14, where you have the court administrator and the committee. Why is there a representative of NSHE on there? And aside from, well, and they don't have to be lawyers, aside from the justice of the peace, the district judge is a lawyer. It doesn't seem to be people that would know that venue. So I'm just trying to figure that out.
Thank you, John McCormick for the record. So this is the advisory committee for the certification of court interpreters. So the focus of this committee to a certain extent is more on the interpreter function and making sure that the interpreters we have meet the minimum standards promulgated by the National Center for State Courts. As far as the membership and the inclusion of NSHE, that was a statutory decision taken by this body, I think, before my time. So I don't know that I can necessarily provide insight on that. And yeah, sorry. I think I'll just trail off now.
Okay, since it's a cleanup bill, you can do that. The other question I have, if you'll indulge me, Madam Chair, is when you talked about small law firms, what is a small law firm? And I'm sorry, I didn't write down the section. I just wrote down small law firms ? You made that reference, and I was just wondering what constitutes a small law firm.
Again, John McCormick for the record, forgive me. If I said small law firms, I don't think I meant to. 'Cause this
Okay,
shouldn't
one
necessarily-
point, my lawyer friends are helping me, 1.270 in section 37.
Oh, okay, excellent. Section 37.
It was deleted language.
Oh, okay. Oh, the partners in the law, I'm sorry. Deleting the section that, again, John McCormick for the record, sorry, it deletes the provision that said a sitting judge can't have a partner, so law firm partner, who's practicing law in the state. So basically, judges can't be a part of a law firm. And so that's what that was, but the way which is contrary to the Code of Conduct, obviously. So, but the way that statute was written just seems sort of anachronistic and unnecessary.
Okay, so they could not be a partner in any law firm.
Correct.
Okay, great. And just as a person who has library skills, the librarian is probably checking in because she might be saying they need supplies. So, thank you, Madam Chair.
Thank you. Other questions from members of the committee? All right, I have a few of my own, and I'll start backwards because I actually also had a question about the disqualification of judges who have partners practicing in the state. And now I can't find which of the many sections you're proposing to repeal originally contained that provision. For those following along at home, it is 1.270. So why would we delete that?
John McCormick for the record. Again, I think forgive me, but I think the way it's written is pretty old school. So the idea was because it's already prohibited by the Code of Conduct, it didn't need to be duplicative there in the old-timey language.
Okay. And why are we deleting section 1.15 that requires the court to recycle?
Thank you, John McCormick, for the record. The idea on this one was from the perspective that that's a court function, and they manage that, and we recycle. So figured this felt like the statutory requirement was not necessary.
Even though we just passed it in 2019.
John McCormick, for the record, if I recall, the statute's been there for a while. It was amended in 2019, if I'm not mistaken.
It was. And the last question that actually, maybe I have two more questions. Going back to things that we're deleting or proposing to delete, why would we take the qualifications of the Supreme Court law librarian out of statute?
John McCormick, for the record, the idea behind that was being that the law librarian is an employee of the Supreme Court should set those qualifications. And that in order to necessarily be a librarian, you have to possess certain qualifications. So the idea was that it's a function of the court.
But is there something wrong with 2.440? Is it outdated? Is it insufficient? Is there a new certification process for law librarians? Because I think it's important that the librarian of the Supreme Court Law Library be appropriately qualified, that the position A doesn't become politicized, and B, that you have somebody overseeing the library who has a degree in library sciences, which is how I read 2.440.
John McCormick, for the record, yeah, the intent was not to modify the qualifications there. It was just to not prescribe them in statute.
Okay. And finally, everybody's favorite section, Section 8. You did mention that there has been a problem with people, I'm taking that to mean parties to actions who are filing duplicative, perhaps unwarranted requests for judges to be recused or dismissed or something of that nature. And I'm wondering, whatever the solution's going to be to that problem in rules, not regulations, is there a reason that we can't just discuss what that solution is going to be and put it into the statute?
John McCormick, for the record, if that is the discussion, we're certainly happy to have that discussion. The preference was to set it in court rule. However, obviously, if we need to discuss that going forward, we're happy to.
And has that discussion already been started?
Excuse me, John McCormick, for the record, yes. We have been tossing around some ideas on potential fix there.
Okay. Based on my questions, are there any other questions? I'm not seeing any, so thank you for joining us and presenting the bill. We'll move to testimony now in support of SB 63. Anybody wishing to give testimony in person in Carson City or Las Vegas is invited to come down to the table, but I don't see anybody, so we're going to go to the phones, please, for testimony in support of SB 63.
Thank you, Chair. The public lines are open and working. However, there are no callers to offer testimony at this time.
All right, then we'll move to testimony in opposition to SB 63. And I do see somebody coming to the table here in Carson City. Please go ahead whenever you're ready. You'll have 2 minutes.
Thank you, Madam Chair, members of the committee. Tanya Brown, spelled Tonjabrown, Advocates for the Inmates and the Innocent. Section 8, we don't agree with, but there's something that wasn't touched on, and I think I want to bring it to your attention. When you're discussing the judges, I have not heard the word senior judge. It could be a senior retired judge who can oversee cases in any court that he wants. And there it could be, and I'm going to say that I'm going to estimate that these judges over the years who've got 20, 30 years in probably have done thousands of cases, and they may not remember every case. And I know that the Washoe County Courthouse, along with the Nevada Supreme Court's courthouse filing offices, have problems with their cases. They're not up to date. They haven't been scanned into the computers. And who's to say that a sitting judge is now going to be assigned a case? He may not remember the case, and the party doesn't want them there. And if the Supreme Court tries to go and look online to find the case, he's not going to find it. They're not going to find it. They're going to have to go to the law library, go into the microfilm, and pull it up that way, which again kind of goes under that qualifications for that librarian. So that's kind of our concern. If you're going to have that language, at least toss in there senior judge, because you have sitting judge and a senior judge. He can pick 1 or 2 cases per year, not even, but he is a party to all of this, and he could be biased and prejudicial in that case, may not remember it. There's no way for them to know this. And then they talked about other cases. Now, I don't know what you would call it, he might, but I know that when I went to the Nevada Supreme Court to look up the case, I had to go on microfilm, and then I spoke to the law librarian about this. And she says, well, all the cases that a party has, the decisions are put into the books, into this. And I went and I looked, and I know for a fact that they had a couple of cases that were listed, but there were other cases that weren't even in the book. So it even makes it more difficult for someone to go in and find these cases when they should be in these blue books, the Supreme Court's, and I don't know what you would call them, but if you go in, the law library office is right there where you talk. It's this wall here with all those blue books, and there's cases missing from those. And that's all I'd like to say. Thank you.
Thank you. I don't see anybody else coming to testify in person, so we'll go to testimony on the phone in opposition to SB 63.
Thank you, Chair. The public lines are open and working. However, there are no callers to offer opposition at this time.
All right, then we will move to testimony in the neutral position on SB 63. I don't see anybody coming to the table in Carson City or Las Vegas, so we'll go back to the phones for neutral testimony on SB 63.
Thank you, Chair. The public lines are open and working. However, there are no callers to offer neutral testimony at this time.
All right, then. I believe that brings us to the conclusion of the hearing on SB 63. I will now close this hearing and move to the last item on our agenda for today, public comment. Anybody wishing to give public comment in person in Carson City or Las Vegas is invited to the table now. And not seeing anybody, we will go to the phone for public comment.
Thank you. The public lines are open. However, there are no callers to offer public comment at this time.
All right, then that brings us to the conclusion of our meeting. Weather permitting, we will be back tomorrow at 1 p.m. And until that time, we are adjourned.